Excellencies, distinguished guests, ladies and gentlemen. It is a privilege and a pleasure for me to welcome all of you to this special lecture on the theme of international law and emerging technologies by Professor Vitit Muntarbhorn, who is an eminent jurist of international standing and who hardly needs an introduction. I would like to take this opportunity to express my sincere appreciation to Professor Vitit for making time from his busy schedule to share his views on an important subject here this afternoon. Today's event is held to celebrate the 4th anniversary of ISC's relaunch on the 5th of September 2019. This year also marks the 3rd cycle of the ISC Foundation, which dates back to 1987. So we celebrate 36 years of ISC history. I am pleased to report that we have made satisfactory progress over the last 4 years. We have held many public events, produced many publications, hard copies, as well as electronic version, established relations with many foreign institutions, and collaborated with local universities and think tanks. Information about ISC's activities and publications is available on our website, which is isc.mfa.go.th. All our publication is free. You can download it free from our website. On the 5th of September last year, we also held a similar event to celebrate the official opening of our new office at the government complex on Jangwatthana Road. On that occasion, we invited a panel of experts to discuss Thailand's post-COVID economic recovery and development. So today we will hear a lecture on international law, which is another important area of international affairs which ISC has been tasked to cover. As customary, please allow me to state again that all our discussions follow the so-called Chatham House rule. The views expressed by the speaker are his own, and they do not represent or reflect the views of the International Studies Center. Lastly, I hope you enjoy the discussion, and I look forward to welcoming you again at ISC's future events. Thank you.
Sawadee krap. Good afternoon, my dear friends and family. Thank you very much for coming. I wasn't quite sure who would come, but it's like a family gathering in here. So a warm welcome. And we're here really to celebrate the 36th anniversary of the International Studies Center. So let's give the center and everybody a warm applause. I hope you'll have a relaxed afternoon with me. It is serious, but not too serious. First of all, let me brief you on the methodology. There's a PowerPoint, quite long, available, which I will show, but because of limited time, I won't go through all the issues. I will choose 6, perhaps, main issues to be dealt with in terms of techno. Then we'll have a discussion period, and I hope I can respond to some of your concerns and questions. And then finally, maybe, if there's time at the end, there are 2 case studies that I can also use. Why? Because it's supposed to help teachers teach, as well as everybody being a teacher at home to teach your children. But if there's no time at the end, no problem. You can take the PowerPoint home, and it's a sort of question and answer case study, which is quite easy to deal with. So with that, without further ado, because it's a family affair, first of all, let me thank the Institute for inviting me here, the director, Dr. Narathip, Vitit, His Excellency, Vitit, who's behind all this, and all the friends and relatives who are here, including Faculty of Law, Chulalongkorn University, the Dean, my great consistent coordinator, good art, and others who are with us and online. The talking point is international law and emerging technologies. But I'd like us to reflect for 5 seconds. What is your image of technology in terms of visibility, of something very prominent in your mind? Have a think for 5 seconds. Can you tell your neighbor now, please, as a family affair, what is your image? And I will show you what I think as my image of technology. Okay? So 1, 2, 3, 5 seconds. This is my image. What is it? The telescopes enable us to see this fascinating image. But it's been there in our minds since, Asian astronomer centuries ago, but more recently visible. This is Andromeda galaxy. And what is Andromeda going to do to us in 3 billion years? Anybody? Andromeda will collide with our Milky Way. And I think this is one of the most fascinating technological stories for me as a learner, as a student. It will collide with the Milky Way, and we don't know what we're going to call it, actually. Andromedae? Milkomeda? Semantics, but today it's semantics and the logic of technology as well. And you know, if you look around, you'll see a sort of blue around the halo. It's a spiral galaxy. And what is the meaning of the blue rather than red in this country of no colors? The blue means that it's coming to us. There's a gravitational pull. If it's red, then it's going away into the universe. But if you look hard and fast, there's a sort of blue that enables us to see that the gravitational pull is enabling Andromeda to come towards us, and we will meet in about 2 billion years. At the moment, it's about 2.5 billion light years away from us. And according to technology, we know the speed of this blue coming to us. It's about 3 kilometers per second coming to us gradually. So I think for me, that's an absolutely mind-blowing personal experience that is very educational and enables me to be self-reflective as well on how technology, telescopes, the Hubble, the web, etc., and the philosopher, the astronomer, centuries ago from Asia as well, identified this phenomenon, which is actually a spiral galaxy coming towards us, and we will merge, collide, and merge somehow. That's 2 to 3 billion years from now. Today, I will try to reduce some concepts, laws, etc., to something quite simple, in a very simple understanding of both international law and technologies. When I humbly use the word international law, I mean a system of rules above the nation state, above us. Something sort of regulatory up there, transcending higher than the state and other actors. And when we look and see the evidence of what it is, when you talk about law, you're really talking about something sort of enforceable. The legal word is binding. And the evidence of this legal framework is through certain elements such as treaties, agreements, conventions, same word, custom, which is sort of binding rules through usage. For example, even if we don't have a written law, we can say torture is forbidden in the practice of humanity. I think that's a custom that we all accept, even though we might not have a law. And Thailand has a new law on this now as a manifestation of that custom. But it was always part of international law long ago, even though they're breaches. General principles of law, maybe something slightly moral. The principle that in war, civilians should not be attacked. That's known as the principle of distinction. Jurisprudence, cases, legal decisions, World Court. The World Court at the moment, famous for Thailand in regard to a certain case pertaining to Thailand, but a famous case now before the World Court in The Hague is to do with climate change. Seeking advice on climate change as to whether we have certain rules that enable us to do certain things, and our responsibility towards not only us, but next generation. So we're waiting for advice on an intergenerational perspective of law now from The Hague. That will count as part of global jurisprudence through courts, local, international. And we use sometimes the word doctrine or doctrine, which is the writings of publicists. Maybe what you write is or can become part of international law, guiding the world community on the preferred options, the preferred way to respect common humanity as well as nature. And importantly, the way we measure international law is not only through those elements, but also through what we call state practice, what you, the diplomats, send to Geneva, to New York, how the foreign ministry and others communicate with each other. Everybody says torture should be forbidden, according to communiques, press statements, NGOs, etc., but particularly between states, that's of some weight. So a lot of this you will see in terms of the gestation of the rules that are now taking place in a great state of flux, because technology is in a state of flux. And with that in mind, of course, the UN isn't far, the international community isn't far. And another word that you will hear along the way is hard law. Hard law means sort of rules that are sort of enforceable, that pressure for some accountability, maybe sanctions locally or internationally. Those are rules pertaining to hard law, as used by me, like the Convention on the Rights of the Child. No child should be punished by death penalty. That's pretty well hard law, and also applied in the nation states. And at the local level, hard law means legislation, acts of parliament, statutory law through parliament. Then you will hear the word soft law, which means really policies, guiding principles. And the most famous soft law that's almost hard is Sustainable Development Goals, which also pertain to us, SDGs, which guide the world community in terms of preferred development for the future. Resolutions in the UN, I have to work with resolutions all the time in my humble role with the UN. Resolutions aren't binding. They're not treaties, they're not conventions, but they might have elements of custom which could bind. Recommendations, likewise, something softer. And then the mixture of both. Sometimes I say hard and soft. You do get this when you look at this spectrum. You might have a convention, a treaty, but the rules inside are quite soft and there's not much of a sanction. So it's a bit of a mix between the framework of the law and what's slightly more flexible inside that law, a treaty or a local legislation. The word regulations, as used by my humble self and others, will also mean hard law. Under the state, regulations could mean also statutory law and more. And in regard to the international perspective, of course, regulations pertain particularly to the hard law of international treaties and conventions. Self-regulation, which is a very dominant phrase in this discussion, is about industry rules of conduct. How your digital industry comes out with a code saying, okay, well, be careful about children, with some self-monitoring and leveraging between industry. Not necessarily touched upon by the state, but left as a code to be operationalized and pressured, leveraged through the industry, through the business sector itself. And the other word, which is probably new to you, is co-regulation. Now, this is very interesting. You might have a self-regulation through industry that is also supported by the state, or shared monitoring between the state and the business sector and stakeholders. A very famous case, anybody from Belgium here? Famous case of self-regulation on digitalization that you will hear about later is on cloud self-regulation in Belgium, which is a code of ethics to respect your personal data in Belgium, but also backed by the state. It's sort of bridging between hard law and soft law, as well as by the European Commission as a regional body up there. So it's a very good example of how we can cooperate too. And international law provides room for cooperation, as well as a sense of responsibility along the way. And you will hear different shades of both along the way. The word technology is about scientific knowledge leading to a practical outcome, maybe a product or a service or a creation. The most famous today is ChatGPT. And if you haven't tried it, well, try it and believe it or not. The word emerging technologies is used to cover new tech or older tech with great potential for expansion towards newer tech. And another phrase that is very attractive now is frontier technologies, implying something cutting edge, something really new and pertinent. And today, if you ask me to do a listing of technologies, this is the UN latest listing from the UN Conference on Trade and Development, 2023. 17 frontier technologies. AI, we'll come to this, and I will deal with it later. And there's also an article from the newspapers last week. Internet of Things, where internet can be connected to many things, your shoes, your bed sheet, etc. Big data, not small, but mega data, and very important because it's collected by mega firms and sometimes also abused by mega firms, mega platforms. Blockchain, meaning technology that can share data and information. And so there's a sort of coalescing of various partners there. 5G, everybody knows it a little bit in terms of your mobile, but very connected in terms of technology that's very much at hand, particularly your mobile. 3D printing, three-dimensional printing that can help you construct. Robotics, which I will merge with AI, and the famous robot, you know, it looks a bit human, but it's not. There's a famous book by a Nobel laureate called Clara and the Sun, which, if you've not read it, it's very incisive in terms of how we merge our love and relationship also with non-humans, at least through literature. Drones, I don't need to tell you, in the news every day, the attacks over there, over here. Europe is a witness to this every day in terms of drones. Gene editing, whereby your genes might be edited so that genetically you'll be improved. And the question is, are we playing with Frankenstein or not? Nanotech, which is small tech, usually medical, and usually running inside you, and we'll come to that maybe later. Solar PV, solar cells, you know it, panels that we wish to see more. But be careful, where are they coming from? And what about the minerals behind? Or what about the elements behind the cells? Solar power, concentrated. Biofuels, I don't need to tell you. Biomass and biogas, to do with bio-waste and the like that can generate some energy which can be renewable, wind energy, green hydrogen, the cleaner one, as compared with carbon, and we'll deal with that in a moment, and electric vehicles, EVs. But don't forget EVB, because the crunch today is EVB, which is the batteries, and the implications of technology for law and environment. So that's the spread, according to UNCTAD. But I will reduce it to something more manageable today, because we have 2 hours together maximum. I will reduce it to the mandate very near me in terms of the Human Rights Council in Geneva, which this year is dealing with 4 tech. Some documents are available on the internet already. 1, military tech, particularly autonomous weapons, killer robots. How do we deal with them? 2, neural tech, fascinating. Maybe insertion here, instructing my hand to move through the neural vibe. 3, cyberbully, bullied on the cyber. And it's linked with, on the one hand, freedom of expression, and on the other hand, privacy, not to be attacked by hate speech, disinformation, misinformation. And 4, climate change. I will not deal too much with cyberbully because of lack of time, because I will deal mainly with 3 here, because I have another list that interests me and I want to share with you. And the other list is this. Biotechnology, such as genetics. I won't have much time to deal with that, but you're welcome to ask questions. Cybercrimes, I should deal with that a little bit, because all these countries are having new laws on cybersecurity, including this country. And don't forget the Computer Crimes Act, which is also very famous. How do we deal with cybercrimes? Through more law? I'm not so sure as a lawyer. And then finally, digitalization writ large, including references to avatars and all the meta stuff, and artificial intelligence, including robotics. And we'll see what timing we have to deal with those. I think I'm going to do about 6 maximum because of lack of time. And then if you wish to discuss the others, we can take them up later. Let's have a look at military tech. Killer robots. What is the state of international law on this? And how do we deal with it? Do we prohibit it or do we regulate it? And what's the channel? Let's have a look. We fear killer robots, especially if they're self-automated, if they decide themselves without human control. That is the fear. And today, there are 2 tracks internationally to deal with killer robots. One is traditional, expanding the traditional, and the other one is new. What is the traditional one? The traditional one is to expand an existing treaty and expand an existing hard law in the form of a convention. And the convention concerned is the 1980 Convention on Certain Conventional Weapons, CCW. Now, this is a funny convention. Why? Because if you want to join this convention, you must join at least 2 other mini-conventions out of 5. Very funny. Basically, the convention is a framework convention to deal with various weapons. But it gives you the choice of choosing 2 out of 5 other mini-conventions that are very specific and operational in terms of the weapons themselves. And the tone of the whole framework is to prohibit, absolutely, or to regulate with conditions. The 5 mini ones that you have to choose 2 out of 5 are these very quickly. 1, on non-detectable fragments of weapons. Shooting at you and you can't detect the fragments within you, for example. 2, incendiary weapons, fire, burning. 3, booby traps and certain types of mines. 4, blinding laser weapons. And 5, explosive remnants of war. Everything that's not exploded, excluding mines. So little bombs that in the trees and so on. They are explosive remnants of war. If you join CCW, you must sign up to at least 2 out of those 5. And the countries in Southeast Asia which are parties to this convention are few and far. Anybody from the Philippines here? No. Anybody from Cambodia here? Anybody from Laos? Interesting. Huh? They have experiences on this front in terms of being parties to CCW. That is one track. But there's also power play. Never believe that law is just law alone. There's always power play, IR, politics behind. Who controls the whole process? So that is why you have another track whereby the power play wants to have a different treaty. Not the old one, but a new one. So they are now also negotiating a new treaty on autonomous weapons. And the concerns that we bear in mind include the right to life, the fear of indiscriminate attacks. The robot decides by itself to attack people, and the lack of humans in control. That is the fear. And the other track is to have a totally new treaty, also power play, by various superpowers, irrespective of the old CCW. I will skip some PowerPoints to shorten the time. The latest advice from the Intergovernmental Expert Group linked with the UN and the CCW is to emphasize elements of law, which are actually very simple elements, both in terms of the old custom, usage, accepted principles of a certain enforceable nature, as well as logic, its basic principles. The group this year said that whatever we have in terms of innovative treaty, maybe a new protocol, a new mini-treaty to add this to the existing CCW, we must highlight the old war-related principle of distinction. You can't attack civilians. You can only attack the military. That is the principle of distinction. You must prove military necessity if you're going to carry out the attack in regard to a military targeting, as well as proportionality to ensure that the military advantage is not excessive and doesn't outweigh protection of people, doesn't cause too much collateral damage. And there is backbone in terms of traditional established warfare-related law known as international humanitarian law, as well as various principles in the various Red Cross Geneva conventions. Some of the representatives of the Red Cross movement are also here to testify to that. So, which way do we go? We're not quite sure which power controls which track. But anyway, I think that with autonomous weapons, particularly killer robots, at least you must have some regulation. At least you must have some monitoring. And if there are violations, killing civilians, for example, some responsibility and accountability to be aired and discussed in the negotiations. 2, neurotechnology. Now, this is very interesting because it's about the brain-computer interface, or the brain and the robot interface. And nobody denies the medical benefits, particularly perhaps to deal with Parkinson's disease. But there are human rights, there are international law concerns, including what about it being a threat to health, maybe rather than being helpful to health? What about the misuse of the tech for human experimentation? The UN paper on this issue is still gestating, gelling, and there are concerns in regard to what some call neural rights as new rights. But I would say, actually, we're just talking about established human rights, established international law, but expanding the leverage to cover neural issues, including mental privacy. I want to keep inside there, private, rather than leaking through neural waves to the robot on my hand. Cognitive liberty, the way that I build my knowledge. I don't want to be manipulated by the contraption. Mental integrity, as well as psychological continuity as a human being. But the fear is where some people want neural augmentation that might lead to a superhuman, super intelligent person, maybe a Hubot, ultimately beyond the robot. Additionally today, in terms of testing at the local level, we also differentiate between invasive neurotech and non-invasive neurotech. Invasive neurotech means inserting something into your inside, the brain or the cranial area. Non-invasive means something outside, but which operationalizes your neural wave towards the contraption outside. Today, through experimentation, and now it's increasingly allowed, non-invasive neurotech is now being used particularly to help persons with disabilities. A headset to help someone who's with disability that can order the hand to move. But the big question subject to experimentation today is invasive neurotech. And that is still being tested in one big developed country. And the rules are still unclear at this point in time, but there are traditional rules that come into play in terms of respect for privacy, respect for physical, mental integrity that can be expanded to cover the neural spectrum. The trials are taking place, and interestingly, one big company that also invests in EV, together with satellites, is investing in neurotech. So you don't have to look very far to the commercial implications of all this. But maybe we should really think hard about emphasizing more the medical side, therapeutic diagnostic side, rather than consumerism to go for Uber persons, which might be negative ultimately. The puzzle from neurotech is a puzzle pertaining to a lot of technologies, and I think because it's a recurrent puzzle, it's good to test this with every technology we're looking at, maybe the 17 that was listed earlier. Number one, is it safe? Is it safe? Safety. Number two, is it secure? And whose security is it? Is it my security? Is it the state's security? Because a lot of the tech is being used by the state to monitor me. Famously, the cameras. Three, the equity factor, poor, rich. Online during COVID. I was online, but think of a lot of kids, children who weren't online at all. Inequitable in terms of dispersion, availability of tech. Equality in terms of non-discrimination. What about tech that's used to discriminate? Profile. And five, privacy. It's about my privacy in terms of data, but privacy is also tested by exceptions. The right to privacy is not absolute. National security can creep in on me, even if I claim the right to privacy for myself. Beware of techno seepage, if it's negative techno seepage. Emerging issues on this front include, do we go for a diagnostic therapeutic versus consumerism? Do we go for prohibition, hard law, or regulation with conditions, sort of hard law, or free market, maybe with a bit of soft law? Self-regulation or maybe co-regulation. And what about responsibility ultimately? I think a very interesting offshoot is neurotech is what sort of medical insurance are we going to build in future? And the big companies that get into this are wise enough to move on this front to ensure that they are covered in terms of liability, at least in civil claims. So there will burgeon a different type of insurance system as we get more and more into these intricate technologies, at least from the market system. But equally important is us, the people, the small people, who also need to be insured by law and by other means against abusers. Cyberbully. I won't get into this too much because there's no time, but being bullied hate speech on the internet, for example, is something very common, and it affects a lot of children. And yet, what you're faced with is a dichotomy, a paradox between freedom of expression, on the one hand, to say, I don't like you, and freedom, the right to privacy, on the other hand, not to be attacked, at least unreasonably. And the blending is not an easy one. And for the lawyer to say you need more law, the lawyer will probably say that, but I wouldn't trust it too much. I would twist it around by saying, why don't we look at cyberbullying from the angle of the need for an educated and empathetic, sympathetic population? A kind population can help to prevent cyberbullying. Don't just trust the law. That is one entry point. If you need a law, then we have a standard. The international standard is you need a law in regard to incitement to hatred that can lead to violence or discrimination. It's a very high standard. Incitement to hatred leading to discrimination or violence means I provoke you to hate that person or to do something nasty to that person. Something very serious. It's a sort of triangular relationship, rather than just saying, I don't like you. The bilateral relation of I don't like you can be dealt with through other means, rather than a stringent law. And remember the abuses, particularly by non-democracies, especially if freedom of expression is impeded. And anyway, both freedom, the right to privacy, and freedom of expression are not absolute. They can be constrained by national security, public health, public morality, but in international law, constraints on basic rights must prove that they abide by a three-part test as limitations on the limitations. If the government, here or whatever, elsewhere, wishes to constrain our freedom of expression, the government must prove that, number one, the limitation of freedom of expression or limitation of privacy is based on a clear, fair law, not just arbitrary discretion by the authorities. That is known as the principle of legality. Exception to freedom of expression, exception to freedom of privacy must pass that test, number one. Number two, the authorities must also prove that it is necessary to limit the right, as well as being proportionate to the risks. In other words, if it's a mini cyberbully, for example, on the internet, it's just not reasonable, necessary, or proportionate to enable the authorities to come crashing in and taking all computers, some of which have nothing to do with the cyberbully. It's just not necessary or proportionate to the risks. The authorities must prove necessity and proportionality. And thirdly, if you are to limit freedom of expression, even not nice freedom of expression, or on the other hand, freedom of privacy, the authorities must prove legitimacy. The ends must be legitimate, meaning maybe constrain freedom of expression against cyberbullying, maybe constrain privacy in regard to cyberbullying, because it is legitimate to protect the rights of other people, particularly children, rather than for arbitrary national authoritarian discretion, which is not a legitimate end. So those are the three tests pertaining to how we can formulate a certain entry point to deal with both freedom of expression and privacy in regard to cyberbullying. I will now jump to a very prominent issue today, which is climate change. And this is also an issue, one of four, being dealt with in Geneva at this point in time. A lot of it's about carbon reduction, and many of you are experts on that. But I will add something on green tech as well, in terms of where do we go with greener technology, particularly renewable, regenerative, and the like. Climate change, as you know, is very much the agenda of the day, and part of it's about fossilization, decarbonization, reduce carbon. The other side is adaptation, to adapt our town and country to new conditions, to be prepared for natural disasters and so on. And today, in Southeast Asia, an emerging issue is where do we go with carbon tax? The lead country with carbon tax is Singapore. Anybody from Singapore here? But Thailand is also contemplating this. But remember also that carbon tax is one entry point. It is not every entry point in terms of dealing with this. The other one is a very topical debate is carbon credit exchange, which is a voluntary phenomenon now whereby you can offset your carbon emission by buying the carbon storage from another sector, particularly agriculture or forestry. Very interesting today that we're becoming more skeptical about carbon exchange, even though it is around. Why? Because it may lead to greenwashing, not real reduction at all, whereas we need to move towards a real reduction of emissions rather than just playing around with what is also very empirically difficult in terms of proving whether you can actually have a credit for something that's very difficult to measure. Another one that's arrived is carbon capture, and some advocate that they can remove carbon from the atmosphere through specific fans. But the question is, where do you go with storing all that? The carbon sinks for storing all this is usually agriculture or the oceans or forestry, and there's a limit to all that. And who deals with it anyway? Big companies or small people who have very little say? A very important consideration among all this is to expand impact assessment, assess the possible impact to the environment, to health, to human rights, and to integrate it into the risk management. And this is based upon now a very well-known set of guiding principles, UN Guiding Principles on Business and Human Rights, which establishes the state's duty to have a framework to protect everybody. Very importantly, the business sector's duty to respect that framework by having impact assessments and risk mitigation. And finally, shared responsibility to remedy. And one very interesting situation now in the States is that young people in Montana took the state of Montana to court. The state of Montana refused to have impact assessment in regard to its environmental law, and the young kids won. That is part of a harder law approach in terms of responsibility and accountability that comes into play also, together now with the World Court judgment, or rather World Court advice on climate change obligations to the next generations coming very soon. But the puzzle here is, please don't forget that every time we talk about the market, there's always a supply chain, the now value chain around it, and then the economic power. And with any market, you have those on the fringe. Monopoly, inviting demonopolization, and also SMEs that interplay with all this in terms of inclusion of just ordinary people in the discourse and the benefits from all this. The other side is technology, which is greener. And of course, we're now heading to COP, Conference of State Parties of Paris Climate Change Conference in Dubai. We have established by words in the UN everybody's right to clean, healthy, and sustainable environment. That's by wording. But what does it really mean in real terms, in terms of rights and obligations? Well, mitigation, decarbonization, adaptation, all those are there. But in real terms, if you test it from what's happening as a hub in this region is going to become EV in EVB. And EVB will need some minerals. Traditionally, the problem was minerals from South America, lithium being used for batteries. But for us, the next challenge is we have a lot of deposits of nickel in this region, which can also be used for batteries. And so it is important to bring in this impact assessment to prevent damage beforehand and to assess possibilities in terms of risk management. Wind turbines and the like, very fashionable. Solar cells, but have a look and see who's impacted upon. If you build wind turbines on traditional indigenous land, then you have a problem with rights of indigenous communities. Likewise, even solar panels from this region, if you look hard and fast where they're from, they might be solar panels, or the elements might come from a region that's actually very problematic in Asia, in a big country at this point in time. So, think around an approach that's empathetic around the emerging EV and EVB phenomenon, particularly prevention of environmental harm in regard to the mining process. I won't go into biotech very much. It's about genetic engineering in a way, because there's no time, but you're welcome to discuss this, and I will jump to the other elements of note. Cybercrimes, and cybersecurity. Every country now has cybercrimes-related law, and Thailand's cybersecurity law came out at the same time as the now famous personal data protection law. Under Thailand's cybersecurity law, if it's a high-risk situation of cybersecurity, the national security people can impound your computer system without a court warrant. I would urge the authorities to be careful on that, because whatever you do, it still has to fulfill the three-part test internationally of legality, necessity, proportionality, and legitimacy. And the approach to cybercrimes at the international level, while we do want to counter terror, be careful with who controls the whole process, and be careful about the political setup of the country, of the region, or whoever is controlling the drafting process of a hard law treaty. Today, cybercrime treaty, a multilateral cybercrime treaty, is being drafted. But there are dangers behind this drafting, including the power play. The most recent draft, one of the problems is that data can be shared very easily between law enforcers of different countries on the basis of claimed cybersecurity, cybercrime, without due regard for all the safeguards that we're talking about. Physical integrity, freedom of expression, right to privacy by everybody, and the various limits on state powers, including the principles of legality, necessity, proportionality, and legitimacy. The legitimate ends cannot just be law enforcement, but people's benefits in terms of safety and security at large. So the preferred option for an international setting, as lessons learned for cybercrimes at the local level as well as cyber laws at the local level, is this. If we are to have a multilateral cybercrime, cybersecurity treaty, it must be very focused on particular crimes rather than being very expansive in terms of great discretion for the authorities to enumerate whatever they want as their preferred options vis-à-vis cybercrimes. The best example, I think even Asian countries can agree to this, is the now well-known European Convention on Cybercrimes, known as the Budapest Convention. The approach of the Budapest Convention is a very specific approach of tackling very specific types of cybercrimes and not leaving too much discretion to the authorities to define the parameters of what they want to tackle. Budapest Convention says no fraud on the internet, no child pornography, no phishing, etc. Rather than say national security concerns, full stop. That is the preferred approach. And some Asian countries are also parties to the Budapest Convention, including Japan, including Sri Lanka, and I think also Philippines, actually. So please have a look at that as a preferred option if the country is to have a cybersecurity-related laws. And I'm afraid our Computer Crimes Act, which was originally targeted to phishing sort of extracting information, is now a very largely implemented national law, largely implemented in terms of national security, which is very much critically analyzed internationally as a law needing reconfiguration, please. And finally, let's have a look at digitalization and artificial intelligence. And digitalization can cover many things. A very famous aspect of digitalization is the right to privacy, the right to be forgotten. One day, this Spanish gentleman in Europe saw his information on the internet about his financial problems, potential bankruptcy. But later on, he cleared all that, and yet that information was on the internet, and he wanted it taken down because it was a breach of his personal data and situation. So he sued. Mr. Costeja sued and went upwards towards the European Court of Justice in Luxembourg and won. And that was and is the origin of what we now know as the right to be forgotten. You have a right to ask the internet to take down your information, to erase it, rather than being there, especially if it's not true. So this is the origin of the right to internet that has crept to other countries, particularly to the European Union's General Data Protection Regulation, which has impacted upon this region very much. Southeast Asia, there's 7 countries now with personal data protection laws, influenced, rightly or wrongly, by the European legislation. And very important element is platforms, internet industry need our consent if our data are to be revealed and stocked. We are the data subject. Those who must be careful, are the data controller and the data processor, and maybe the companies or maybe the ministries will also need a check and balance in terms of a data protection officer. And Thailand's been dealing with this now in terms of little legislation on which type of data protection officer for which sector of the community. Banking, maybe, or not. Medical, security, and very importantly, the need for some due diligence to check, to test whether it impacts upon people's lives, privacy, and basic rights. And the fines in Europe have been enormous. 4% of the national income of the big companies, well, the mega ones you know about. And some of you will be interested to know that the new law in Europe, also impacted upon us, is the EU Digital Services Act 2023, now implemented. Interestingly, the Digital Services Act is more targeted to protecting children from being targeted, especially by advertisements, and also to move towards transparency of algorithm. Algorithm is the instructions impacting on us through instructions through data being targeted to us in terms of various preferences. US laws also emerging in terms of a claimed right of access to algorithm, to know that it's there and what it's about, to know how it profiles, as well as the right to remedy. And this is linked with AI in a moment. Thailand's law is now in full swing, but I would say that the other law is equally important, protecting my personal data on the basis of my consent. But be very careful, it's also subject to limitations, such as national security. And some of the new legislation, the little ones coming out, are now to exempt the authorities from the obligation to respect my data. So I would say, I would also emphasize the need to concretize access to public information law, which we have. I want to know what you in the ministries, my friends, are harboring in terms of data, beyond my own data as well, as a check and balance. And the puzzle. We're still living with the old computers, or my old mobile. The new ones will come one day, particularly under quantum computing. And the synergy created by quantum computing and all the data and everything through their so-called qubits, the process is known as, very, very sexy term, entanglement. But will it break your encryption? So please be careful. Nothing is secret on the internet, ultimately. no anonymity, the emerging quantum computing. Finally, AI. We now have a multilateral framework, but it's soft law, and it's UNESCO recommendation that came out in 2021. It's sort of hinting at right to privacy, basic protections, do no harm, proportionality in terms of what the state should do. So very general, sort of ethical guidelines, no real sanction, plus it's a recommendation anyway. But it provides an ethical framework. But for the lawyer, we're debating on whether you need a soft law approach or a harder law approach. And the harder law approach actually is now seen again in the European Union. I'm not flagging the European Union on everything, but it's just that these issues are very much seeping from Europe to other regions. And we need to be critically analytical, aware of all the good and not so good implications. The European AI Act is on the verge of being passed. It's passed Parliament already, and now it has to go through the Council. It takes a hard approach with this segmentation. Number one, prohibited AI. I'll come back to it. Number two, high-risk AI. And number three, other AI. And AI meaning today particularly creative AI, generative AI, such as ChatGPT, and big companies also interplaying with lots of legislation as well as litigation in Europe. The prohibited AI include subliminal AI, which plays with your emotions, which activates the psychography, the psychology of children to be violent. That subliminal AI manipulating emotions is prohibited. Number two, the AI that profiles you and classifies your data to ensure that the state knows whether, so-called, you're trustworthy or not. It's a social scoring, social profile. This is also prohibited, and the social score, social profile, is already used extensively in Asia, so please be careful. It will be prohibited in Europe with transfrontier implications. And 3 and 4 are subject to qualifications. Remote biometric facial recognition, far away, not the close ones at the immigration, but when you're out there on the streets protesting, for example, also dangerous for people's rights in a way. There are some exceptions, however, in terms of law enforcement, but with safeguards. And likewise, real-time biometric surveillance with some exceptions. The second category is high-risk AI, and that includes law enforcement-related remote biometric, and that needs various so-called guardrails in terms of due diligence tests, assessment, and risk mitigation to ensure that people's livelihood, safety are guaranteed as well as their rights, subject to notification to a national agency and overseen by a regional body, with also very heavy sanctions for violations. And actually, the latest implementation of the European Digital Services Act now can punish through sanctions vis-à-vis 6% of your global earnings if you're in breach of EU law, and that's a lot of billions. Another front is the Council of Europe, which is another body, and it's working on a more general treaty, sort of hard-soft approach, which I don't need to get into. Interestingly, ASEAN is planning an AI plan by next year. I would say, as a guess, that ASEAN will work towards a facilitative approach of wanting more AI to be the lead region, etc., rather than a hard law approach of regulation and prohibition. But be careful, because there are implications, because some ASEAN countries are still waiting for democratic space. The national. One big Asian country has now moved towards a regulation on algorithm registry. to make algorithms transparent, because algorithms can also be biased, as well as the data sets that are used to train AI. You know, the robot has to learn, and so the data going in, if it's genetic data, the global genetic data spectrum is usually genetic data of Europeans and North Americans, rather than Africans or Asians. So it's going to be biased already in terms of genetic data. So be careful there. And the algorithm itself might also be biased in terms of the sets of the equation or formula directed against or vis-a-vis or in regard to one group or another. Another regulation of this big country in Asia is against deeper fakes in terms of deceptive AI. You know, be very careful with your voices now on the computer, on your mobiles. It can be recorded, it can be twisted. And even in the newspapers today, some bankers were tricked into believing the voices of their customers as deep fake. And in this country, there is already a regulation against deep fakes, including hallucinations that can be generated through these new deceptive technology. The draft Thai law on AI actually follows Europe a little bit in terms of prohibitions in regard to social scoring. But I'm interested in other aspects. I want to know whether the robot's deciding my fate. I want to assert my right to know. I hope that will be in the Thai law. Transparency, explainability. I want kids to be able to read the script in terms of the consent form, rather than these long, long spiels of standard form contracts, which are very difficult to read. So the puzzle. There's superpower rivalry. The Asian setting is also very constrained, so be very careful there. And there might be imbalances in terms of data sets and algorithmic biases, together with intellectual properties, copyright, and patents. I have no time for that. Human genetic data, synthetic data, and the like, and competition for chips. Famously, everybody's buying up the graphic processing units as linked with the new generative AI, which can create, which can write, which can paint. And what about super AI that's coming in? And what about when there's no electricity? What do we do? Together with human control versus tech autonomy. And what humans are to control? Democratic humans or authoritarian humans should control? Or self-control by the robots? So the challenges very quickly include subliminal drive of a destructive kind, social scoring, social profiling, targeted vulnerability, selling adverts, through adverts to children, for example, automated attacks, likewise, state control, excessive data collection, algorithmic opacity, robotic screening without informing the data subject, overdue of content moderation, taking down too much by the industry itself through self-regulation, even though there's an oversight board. Millions of items are taken down by the oversight board of the big platforms, sometimes unjustly, sometimes arguably, as well as competition for control of power and chips. Too broad interpretation of exceptions to data privacy, such as national security, clandestine mapping of mental state, known as psychography. You know, the goggles that you might wear can also record your facial expression, nose twitch. And it can pattern what you are in terms of your psychography, and it can profile you in an unbalanced manner, which will affect you and your families ultimately, even though, of course, we don't deny the medical and labor-related benefits. And the impact of cumulative data should not be underestimated, as contrasted with minute data. And what plagues me is this: what about a world without electricity? You know, in that country where there's a war on in Europe at this point in time, one bomb, one disaster from flooding, there's no electricity. And what do? The other tech, the human tech of survival, is also very important. What about future directions, very quickly? A mix of hard law, soft law, maybe, but we do have some guidance already. The SDGs, and we have the UN Secretary General's Common Agenda Agenda of the day is there already to some extent. The need to connect people fairly, avoid internet fragmentation, protect data, apply human rights online and offline, introduce accountability, promote regulation of AI, digital commons whereby we can share some information free as a public good. And we have a summit of the future coming up next year. It is likely that we will head towards a global digital compact. A compact is not a treaty, it's more of a soft law. It's like the SDGs. I don't think they're going to go for hard law. It's too difficult to negotiate internationally. So we'll wait and see. And will the UN do monitoring of AI and the like? Well, we are also bound maybe for a code of conduct, soft kind, on information integrity, as well as implied action against misinformation and disinformation, but not forgetting the need for human capacity in terms of an educated and empathetic, sympathetic person in his or her or their relations with others. Practical options involving many stakeholders quickly: technological, education with empathy, overcoming online gap, making some data digital commons, peer support, such as counter-speech to protect those violated by cyberbullying, balance contractual obligations, your click and the long contracts there, yes or no, should be legible and understandable, accessible filter and techno-screening based upon human rights also, enlightened self-regulation, maybe mixing with co-regulation and regulations at large, as well as human rights due diligence to evaluate, to test what might happen and prepare as a precaution with measures to mitigate, lessen the risk. Maybe from a consumer perspective, certification of products as well, together with labeling and consumer leverage, as well as stakeholder participation in the whole process. Maybe measurements such as technology index, which we have, or gender index, scorecards, and so on, in terms of progress rather than regress. As a person who's dealing very often with implementation issues, I would say there's a 10M situation here, very easy in terms of the preferred options in terms of implementation tools to match between good law and enlightened technology. And what do we need? We need good laws. If we have not so good laws, try to avoid implementing them, please. Suspend them. There's so many not so good laws globally. Good policies, good programs, good practices, good mechanisms, good resources, transparent data, disaggregated, good education, good remedies, and good space for changes and reform. And a final reflection, because we are dealing with law a little bit. International law is often a guardrail in regard to state sovereignty, what the state claims as untouchable or nearly untouchable. Traditionally, international law was very much based on respect for some degree of state sovereignty in terms of the state's rights and obligations between states and between states and other actors, international legal persons like the UN. Later, that notion has become more oriented towards obligations, towards people, populations, based upon, all the same, dealing with the animate, the sentient, the person who feels, the community that feels, individuals, families, and communities. And today, extended more now to the environmental perspective, with the interests of life at stake, living beings, the right to nature, the right to breathe, as well as the right of nature to be protected. Humans should be stewards for the next generations, but also to respect the world as the world in its cosmology as well as its ecology. Now, we are faced with the inanimate, non-humans. They don't feel, or at least we don't think they can feel, the non-sentient, such as AI. Maybe we also need an evolved understanding and transformative understanding of the new sovereignty at stake. It is the advent of a shared human sovereignty that is now at stake, especially when we're dealing with the inanimate and the non-sentient. And we claim all the time the need for human control, but we are also faced with power play on this. Power, control, checks and balances in regard to power. And I believe maybe, just to tease you a bit, there are 3 human C's that differentiate us from the non-humans that should be part of our understanding of sovereignty. And these are the 3 C's as a present for you. Conscience, consciousness, and care, cum consideration towards life. That is what makes us human and sovereign in what we are, as well as the state that should be part and parcel of us. And if that is the advocacy of a new sovereignty shared between humans in the face of non-humans that are coming towards us, then maybe there's a final puzzle that we can all unravel together. Demystifying our law and more interface, humanizing through material and spiritual embrace. To be and not to be, and choose to be not only techno-savvy, but also tech, yes, happy. Simply to be free. Thank you. We have question time. Thank you. Any comments?
Well, thank you very much, Professor Vitit, for that very stimulating and also provoking presentation. Now, we can take comments and also questions. Who would like to start? Well, if nobody wants to start, I will take the privilege of the organizer's privilege of asking you one question that I always find nagging, because we often feel that in our dealing with cyber security and cyber bullying or whatever, we often talk about the abuse by the authority, abuse of law, abuse of regulations, or abuse of policy or whatever. And I think you also made these points quite clear in your presentation. But what about the abuse of the individual? The people, and I think a lot of these cases have led to crime. And when we talk about cyber crime, usually because of the abuse by the individual or groups, private groups of people, criminals or whatever. I mean, how do we deal with those in terms of international law?
Thank you very much, my friend Dr. Nison. Any others at the moment? Yes, I'll respond to you, but just take 2 or 3, okay, please. Yep.
Who to start? Okay.
Thank you very much. I do have 2 questions. First of all, let me tell you where I come from so you understand the questions I have. I come from the National Broadcasting and Telecommunications Commission, and I'm Executive Director of International Affairs. So I also work with the International Telecommunication Union. My first question would be the issue that we discussed a lot under the ITU, which is with all the technology coming, we have been regulating the telecommunications, but what about the new technologies? And we are even puzzled in that forum of how to regulate. We start from OTT over the top, now we have AI metaverse, so we would like to hear your view a bit about it in terms of regulations. Part 2 would be, now we are also doing many free trade agreements, and before this, the free trade agreements are about trade. Now free trade agreement, we start talking about digital trade, and oftentimes we start discussing about this too. Do you view it as the opportunity or the risk? And should we, as the negotiator, be careful or be cautious about this, about where it's leading us to? That will be my two part of question. Thank you very much.
Thank you very much. One more?
Thank you. My name is Dr. Sivanut Thong. I'm from Mueller Foundation. I'm the head of Mueller Foundation Legal Clinic, and very thankful today that let Thai NGO understand about technology that gonna be affect us a lot. We taking care a lot of vulnerable people in Thailand and also outside of Thailand. And what Dr. Vitit said about young generation who gonna be empathy to each other to create like a new population to understand and to use AI. So I think a lot about the Chai of Thailand and of ASEAN to understand this issue as well. And I found that lately I worked on the cases of about 128 Chai from Myanmar that come to Thailand and study in Thai school, but we have a problem about that. We expect that they did not get the regular immigration, and so we deport them outside the Thailand. And right now they're out of the system of education. So I think a lot of bullying happen in the internet on the Chai and on the teacher on that. And I don't know what to do right now, but I don't know, it's possible that if we think about how to help them and try to make it better, like raising some fund to help them to get education in Thailand and being regular immigration. So it's like it's past the not empathy around in ASEAN as well. So I don't know how we're gonna change this, because if we not gonna change, it's gonna happen internet, and many kids gonna consume that, and I think it's just a question for Dr. Vitit right now. Thank you.
Thank you very much for those three important inputs. First one is about crime, particularly cyber crimes. We are totally conscious of the need for effective laws, policies, and practices against cyber crimes. And the tools are already there to some extent. General criminal law, cyber crimes related laws, computer crimes related legislation, etc. Quite a lot of them. The advocacy here is to balance these laws well with considerations of checks and balances in terms of protection for people. And the danger or the difficulty is too much discretion for the authorities or with the authorities. And the international advocacy is to say, look, discretion should be very constrained rather than very broad discretion by the authorities to take action against people. And that is why internationally, in terms of international law and human rights, we have this three-part test. Legality, which is claiming that the law or the action must not be arbitrary, it must be a good law, a transparent rule of law type. Secondly, the dangers, the actions relating to dangers must be considered in the perspective of necessity and proportionality. And third one is legitimate aims. Part of the problem of many Thai laws, I'm afraid, in the criminal area is that they don't quite fulfill the three-part test. And that's not because of me, necessarily, but because of the UN monitoring as a whole, which suggests that we need to reconfigure some of our laws, including emergency decree, which is very famous on many fronts, computer crimes law, and various other crime-related provisions of the criminal code. So it's not a negation, it's not a denial of the need for laws, but to have more balanced laws with checks and balances. And if you work towards the international setting, I've already added the caution that we now have a process of the drafting of a cybercrimes treaty subject to power play. But at this point in time, one should be very cautious because there are provisions in the draft which are very extensive and beyond the limits of what we would advocate internationally, including the potential of very free data flows between law enforcers without due regard for privacy, various basic freedoms, presumption of innocence, and so on, that can be affected by overzealous exchange of data. So that is the advocacy, and that's why I said, if you really want to look at an example, not because I'm advocating Europe, but it's just that some Asian countries are also parties to the convention. The Budapest Convention is generally regarded as the more balanced convention of something very specific in terms of attacking cyber-related crimes. So a particular listing of crimes such as child pornography, fraud, etc. Secondly, a lot of this is going to be linked with some of the UN-related agencies, the multilateral agencies such as ITU, in terms of communications, as well as copyright, WIPO, etc., together with the human rights arm of the UN, etc. We have a sort of direction already with regard to the common agenda that I was voicing, as well as the discussions towards the summit of the future next year. And I'm sure that ITU will be very much involved there. The messaging in terms of international negotiations is that it is highly likely that many of these considerations will creep into the negotiations of free trade in future. So the invitation is really to take stock of the various options that are now arising, and not because we like Europe or not, but European laws, not human rights laws necessarily, they are economic-related laws. This is from the European Union, 27 countries, not from the Council of Europe, 46 countries, with one big country now expelled. We're not talking about the Council of Europe, we're talking the impact of European Union, slightly extraterritorial impact actually, with now the Digital Services Act applying, together with sanctions for Thai companies also working in regard to Europe. And next year we will have the Digital Markets Act, which will impact more on the competition between different types of companies, together with the digital spectrum, impacting on Thailand as well. So that is the European nexus, so to speak. And we are negotiating a free trade area, maybe, with Europe now. So it comes in. So my advice is be slightly prepared. And we don't need to reject it, because we're also evolving an AI law at this point in time. But I've said already the AI law is already influenced by Europe, but there's some elements that I want to have as clear elements, such as I want the right to know that there's a robot there, and I want it explained. And that is part of the UNESCO framework internationally of explainability and transparency, as well as some of the legislation arising in the US. So that is a caution. It's coming, like it or not. We're not necessarily in favor of that region or whatever, but this connectivity, particularly of the cyber, as well as the cyber laws, as well as the various trade-related areas are coming in. And ASEAN itself is interplaying with this. But as I said, the ASEAN framework is much more a facilitative framework of we want to be in the lead, rather than one that focuses very much on basic protection, such as protection against too much targeting of adverts to various vulnerable groups, such as children. Or now, we just had a court case in Europe just a couple months ago, the potential merger of data from different platforms owned by one mega. And Europe just said you can't do it without consent. European court just said you can't merge, even if it's under you, big M up there, but the various platform related, the other ones, but under you, you can't merge. So there are these safeguards, but that's the hard law approach. Whereas in the States you have a mix. You have state legislation separate from federal, which can go either way. I mean, you've got California at the moment with a draft law on transparency, as well as prohibition of targeting of AI in regard to children. or various vulnerabilities. Or there's another law in another state which wants to set up a supervisory body or to be supportive of the federal government. So different ways of approaching harder and soft without necessarily a federal approach yet, subject to the discussion between the top gentlemen of the executive branch with the mega companies the other day, which invited a soft law commitment from the big megas in the United States. So the US is a conglomeration of different approaches. But what I'm saying now in regard to what you have to deal with is that it is part of the trade and commerce process very much, together with enhancement of the rules next year in regard to a forthcoming Digital Markets Act, which will be even more circumscribing in terms of basic protections and the famous word, the guardrails. Finally, children and others. Well, in fact, already we've flagged the concerns of children for a long time, particularly against abuses on the internet. And there are already many laws here and there. There's a child online law in the US. The Thai law can be used, but it might be difficult. We have child protection law. We have criminal code, which has been expanded to cover pornography on the internet. On computer crimes law can also be used to protect children in Thailand. So there's quite a lot of laws. But the whole spectrum invites different stakeholders to come into play. What about the business sector? It's not adequate just to have a state law. So we want business sector commitment, additional maybe self-regulation and monitoring against abuses on the internet. Or maybe to work with the children themselves in terms of child support system, different entry points. You know, when a child is attacked on the internet, often, what's the kid to do? The person wants some psychological support, obviously, to deal with it. So peer grouping up, call it peer counseling, is also possible. And the other side of the fence is this. We, parents, also have to learn to enable children not to be too dependent on the MEMS and on the computers all day and all night. It is just not logical or human. There must be some special times to be liaising with technology and to stop at a given time, to let the ordinary elements of being human operate. Leisure, talk, breathe, write, rather than being fixated on the digital. And today, the other danger is this. Previously, we always said that technology was value neutral. It's the humans who manipulate techno. But today, the world community is coming to the conclusion that techno is no longer value neutral, especially if it's self-automated, together with synthetic data that's coming into play. So it can also establish its own values increasingly and take up values which might be detrimental or beneficial to humanity. But the whole point is that we don't want that to happen because we feel and we still claim that humans must be in control and must be in the loop. We still claim it. But to operationalize it is not easy, precisely because there is power relations behind it. Control, rivalry, as well as democracy versus non-democracy, particularly at play in Asia, which is the most populous continent on Earth. So please look at a package of strategies and not forgetting the human interaction elements, the humanization process that goes beyond just a law or technology. Parents also have a role in this. Other kids have a role in this. School teachers have a role in this. The empathy factor of socialization is very important. You know, I'm a teacher by coincidence, and for 2 to 3 years I was online. And I give you one example. I would have to switch my face on all the time. There's facial recognition. But the students, sometimes none of them switched on the screen. And they never gave a thought to it. And I, as a very relaxed teacher, had to question myself as to what psychological strategy I would get into. So I consulted many friends, and some said, oh, order, But I don't mind students sleeping in my classroom as long as they do homework. All right? But what I do with this 20 potholes, all black or more. So after consultation, a very humanizing approach of socialization through which I learned, I said to the students, I always say, น้องๆ, brothers, sisters, น้องๆ, would you like to try to switch on? Unless you have a reason not to switch on. And there, I think, was really nice human interaction, not because of me, but because of the wisdom of others. They started to switch on. And one or two said, I'm not switching on because I'm borrowing the computer and I'm in a place which is not very nice. Which is fine by me, so okay. And funnily, the switch on revealed one nice student had this background of Versailles behind him. Whereas my background was my bedroom, very unruly bedroom in terms of not very orderly bedroom. So it was the privacy being revealed, actually. Psychology of online privacy should be studied. And so in the end, yes, they switched on. And then they came back to university after 2 or 3 years. Year 1 and year 4 didn't know each other, a lot of them, until I invited them to dinner. And you know what they called themselves? I was just shocked as a Hubot. They said kun to each other. Young people saying kun to each other. The kun in Thai is such a distant thing, particularly between the young. And I was shocked. They weren't calling each other by nicknames. So through dinner, through lunch, through talk, chit-chat, they started to ease towards each other. These are human elements that should not be forgotten in terms of our socialization process. It is not just technologization. It is humanization through shared education and socialization that we also have to personify. Thank you. Any others?
Yes.
Yes.
สวัสดีค่ะอาจารย์สุพันธ์ภาษา Director General of the Department of Treaties and Legal Affairs. Thank you very much for your enlightening presentation. It's always a pleasure to actually listen in, and I'm sure you had great fun in preparing this presentation. You gave me a lot of food for thought, and the one thing that struck me is actually, I'm not sure whether we know what we want yet from the law that we're trying to create here. The puzzles that you put on the screen, I really don't have an answer yet on what the direction is as the legal advisor for the Thai government on international law. I'm still looking for that point where the government, what is the role in terms of creating that international law that we want to see? I think technological advancements have always been the benchmark of human advancement, of human well-being, how well we've been doing. And really technological advancements is really the test of how much power you have in terms of the political engagement. Those who have the power are those who have the say in how the politics and how the relationships are defined. So I think there is two sides of the coin. There's the good side of technology and, of course, the bad side of technology. FTAs that we're negotiating with the EU, of course, we would like to see that digital commerce happening with us in the EU. But, of course, it comes with a price. We also have to have our own kind of standard to be able to guarantee to the EU that they convinced that we have the right, background to be able to engage with the EU. But also the fact that I think government is more keen on doing regulation, keen to a point where sometimes we go overboard, like the issue you said about the cybercrime convention that's being negotiated right now. We may go overboard in trying to secure that confidence government officials need. But in terms of facilitation, which I think is something that international law really needs right now, we're not really sure of how to go about it. Because for technology, it's not the government that drives it, it's the private sector. And government cannot do that without the private sector because we don't have the funding needed. So how do we become the facilitator. How can we make international law the facilitator in order to have the technological advancements that are needed? Thank you.
Thank you very much. That's one.
Hello. Okay, thank you very much, Professor. I'm Salinthorn Thongminsuk from the Thailand Development Research Institute, and I'm also a legal expert in the AI Governance Clinic of EDA. I do have a few questions, but actually it's very similar to the person before me. First of all, given the influence of the EU GDPR on domestic law of many jurisdictions across the globe, you think the EU AI Act will have a similar influence on domestic laws of many regions across the globe? And secondly, you did mention the different level of regulations of AI, soft law, hard law, and also ethical guidelines. Do you think the implementation of hard law in Thailand would kill the industry, or is it necessary in your point of view? Thank you very much.
Thank you. Was there one other? Yes, go ahead.
Hi, hello. Hello. Okay. Hi, my name is Printorn Kodamrong. I'm from the Thailand Institute of Justice. I would like to say thank you very much for such a great and innovative talk today. And my question for you is this. Is international law able to keep up with the development of emerging technologies? And if not, what do you think are some of the gaps in these checks and balances that you've talked about today, that you have identified, that is sort of is it primarily an enforcement issue that you think is the problem? The reason why I ask this is that I think in all of our experiences, I think that the drafting and amending of legislation is usually a game of catch-up with developments in society, and particularly with these technologies that are now sort of crossing into the realm of science fiction, seemingly, at this point. I'm just wondering, since there's the principle of no punishment without law, I'm wondering if these gaps can prevent people's justice needs from being met. So that's my question. Thank you.
Thank you. All excellent comments and questions. Number one is the role of international law, and particularly to deal with the new technology. International law, human rights, these international elements are basic minimum, not maximum. States should not do under, be subpar. If states and other actors wish to do more, great, but don't go under the minimum criteria of preferred operations and respect for humanity. So I would start there. What we're talking about is not a negation. It doesn't deny initiatives of countries and regions to go beyond the basic minimum in terms of basic protections of humanity and nature and so on. And I would say that lawyers should be also very open to an understanding of power play in terms of what's behind new laws, new conventions, and so on, as I highlighted through a certain skepticism towards the new cybercrimes law. So who has the democratic hand behind all this? And in Asia, we have to be very careful because on many fronts, we have constrained civic and political space. In regard to guidance of preferred development of international law, I've already listed various possibilities in terms of the puzzles and also the guidance from UNESCO. And very easy tests such as, is it safe? Is it secure? Does it respect privacy? All those are elements which can help us in terms of testing. And due diligence, meaning we need to take stock of dangers of what might arise in terms of impacting on humans, nature, and so on. Take precautions, do no harm, and build in those mitigation elements into our risk assessment and risk-related measures. So in that perspective, the lawyer cannot provide all the answers at all. In fact, part of the problem of negotiations of some of these treaties internationally is that those sitting there tend to come from lawyers and some ministries, but not engineers, not ethicists, not stakeholders, civil society, human rights defenders. So these are little loopholes that we should fill in terms of the shared negotiation process if we're working towards hard law. And of course, if it's soft law or hard soft, we know today that the role of industry is very, very important. And the question also is which industry? Because we know very well that in terms of self-regulation, the most famous ones interrelate with the mega companies that are all over there, not the mini ones over here, which means that the power relations in terms of enabling developing countries and developing communities to evolve a certain technology is also very important. So we're back to the other principle that I listed in terms of puzzle, equity, the sharing of resources and power in terms of also technological resources, education, and financial plus non-financial resources. And that's why you have this dynamic always now, increasingly in terms of if you can negotiate multilaterally, what cake do you provide for the developing countries? But I would see it not as a sort of give-give in terms of a donor-donee, but also more as a sort of shared responsibility in terms of sharing, in terms of equity of resourcing, some of which were or was built through unbalanced power relations, including colonization in the past, which also made use of technology, you know, your industrial revolution. Or where did the coal come from? Or where did the iron come from, if not developing countries? You see, so you have that historical perspective, which is very important. Also enhanced by the need to teach histories so that we can understand the power relations from the past that still shape the present. So that's calling for a more rounded approach in terms of negotiations together with multiplicity of stakeholders and actors in the negotiation process, rather than just enabling you or me to go and sit there and negotiate. Because a lot of the wealth of wisdom coming to me through here is through many other sources, not because of the law at all, but through readings, chit-chats with many others of different disciplines in an interdisciplinary, intersectoral world. Secondly, influence of GDPR and the forthcoming AI law. The draft AI European Union law already has influence in terms of Thai draft decree or regulation on AI. As I said, the prohibited AI in the draft AI law of Europe is already there in the draft Thai law. No social scoring. Remote surveillance, facial biometric, probably there, and as well as social scoring. So we are already influenced by the undercurrents or overcurrents in Europe. Why? Because it is the most hard law-oriented approach at this point in time, with various safeguards, which has been through a very consultative process. You know, the European law that comes through, not because I am lauding Europe, but it goes through a very participatory process. Initiation from maybe the Commission, plus, and a lot of vetting through the European Parliament, which was open to parliamentarians, but also their colleagues from other industries. And then now towards the political arm, which is to the Council. So it goes through a very filtered process of coming through as legislation. And impliedly, it has extraterritorial implication. So actually, at the moment, you know, the matching, particularly in preparation for FTA and the like, is that you have a conglomeration of laws arising in terms of digitalization, ranging from the General Data Protection Regulation to the Digital Services Act, which increases scrutiny and sanctions, to the AI law coming up, as well as the Digital Markets Act coming up next year, and whatever else as very integrated regional system of a supranational kind, which has impliedly extraterritorial implications. So It's there. We're not saying that it's the best necessarily, but take stock of it and build on it. And you might have certain flavors locally that you could add to it. The approach of many Asian countries is to have very strong exceptions. That's what you should be very careful with. Right to privacy, maybe, or safeguards, but strong exceptions on the basis of national security. And even now, the little legislation, subordinate legislation coming through in Thailand is about exceptions, if you look at it. Some sectors are exempted from the personal data protection law. Security, banking, etc. So be careful, because even if there's a sort of slightly enlightened framework, within the political setting of a certain society, often constraints creep in because of the power base, justified by various rubrics such as national security, public order, public health, and public morality. And that's why international law is very careful about those rubrics and tests them through various strong criteria, such as the authorities must prove legality, necessity, proportionality, as well as legitimacy. Finally, from our friend in terms of the institute concerned that I know very well, the way that it's emerging is that it's not an either-or situation. You might have hard law, but it's happening more at the regional level. But the regional doesn't necessarily end there. You have the multilateral. And what we've been talking about is that if you look at the multilateral, it's actually quite difficult to have hard law. Why? Because there is power play. And even the CCW, the Conventional Weapons Convention, most ASEAN countries are not parties, even though I would say it's not a bad convention. I mean, we should forbid blinding laser weapons. We should try to clear explosive remnants of war and be helpful to developing countries, but we're still not parties, many of us. And we're not there to expand that CCW. And now the interface is that there's a new treaty arising, maybe, through the UN General Assembly, through power play of superpowers, which is separate from that older treaty, which is there already to be used. So we don't need to reinvent the wheel necessarily, but to make good use of what we have, if we have the political will to do so. Lastly on that, as I said, we're working towards a digital compact next year, and I would hazard a guess that it will be a soft law. But it will have many elements there, as listed already, together with the equity element of sharing more. But also, it's there already, I mean, in the components that I listed for you in terms of some regulation on AI. Now, which level? Well, we now see the regional level, we now see the national level. But the international level is going to be difficult because of power play in part, which is life, but we have to be very careful. And if they're going to come out with a very broad draft, such as the cybercrimes law, then we have to be doubly careful. Not because we're lauding a particular region, but because we have lessons learnt in terms of shared wisdom from different regions. And not forgetting, as I said, the simpler elements of humanization, socialization, from which we can learn from very simple communities, like the best teachers, the best parents, the best young people already help in terms of helping as peers or as communities, providing a certain cushion and embrace for those kids and others who might be impacted upon negatively at this point in time and in the future.
Okay, I think we have taken up a lot of your time already, Professor Vitit. So I think we will end there unless, okay, I don't see any hand raised.
I have one question.
Maybe one last
yes,
question,
yes.
and that's it.
And then I have one question to our participants to end.
Thank you, Ambassador Anuson. First of all, thank you, Professor Vitit, for this thought-provoking presentation. My name is Vitit Muntarbhorn, Counselor from International Security Unit, Ministry of Foreign Affairs. I wish to thank the International Studies Center for organizing this wonderful event as well. I have a specific question regarding the cybersecurity in terms of peace, inner peace, and security. I'm part of the UN negotiation process on the cybersecurity, and The discussion that has been going on for quite some time is the applicability of the international law in terms of cybersecurity. I think for the past few years, we see the rise of the use of cyber in armed conflict. And I think cyber warfare is inevitable for the future. Of course, we have the IHL. But my question is, of course, as Professor Vitit mentioned, that power play is really important in terms of the negotiation for the new treaty. New treaty on cybersecurity is one thing that we have been considering for quite some time. I think power play will be a really important factor. But for the IHL, as you and everyone may know, that the cyber domain is totally different from the physical aspect of the armed conflict. So do you think the existing IHL is enough to cover the use of cyber tools for armed conflict or cyber warfare in the future? And because the principle of distinction, proportionality may be different in terms of physical warfare comparing to the cyber warfare. First of all, do you think the existing IHL is enough? And secondly, if not, what is the way forward in terms of legal or academic aspect? Do you see we will have the new additional protocol to the Geneva Convention, or do you think the totally different convention or treaty should be the way forward for us? Thank you.
Okay, Professor Vitit, there's one more.
Yes, go ahead.
I think that's just.
Yes, that's a good question.
I take it that this is the last question.
Right. Thank you very much. Yes, one more. Go ahead.
Hello. I have two questions. The first question is, do you see the possibility for the law against discrimination for AI? Because we as a people, we are prohibited to act the hate crime against each other based on the genders or the nationality or ethnic. But when it comes to AI, I think AI has this feature where it can recognize faces and or certain characteristic, and it may deem that person, for example, a terrorist. And I may go for an extreme case, but there are some occasions where the AI compute the certain characteristic of the people and deem that person terrorist and then kill that person. Do you think do you think there will be a law against discrimination in this aspect, or do you think there will be a development for human rights law? And for my second question, I think you have already partially answered to the question, but you have mentioned that when the state wants to intrude people's privacy, it has to prove the necessity in that act. But my question is, if the intruder of privacy is the private enterprise, and that private enterprise has far more globalized that its power transcends beyond the border of the state. How do we prevent the invasion of privacy? Based on my understanding, I think at the time we depend mostly on the domestic law of the host state. Do you think there will be international law to cope up with that? And do you think that the idea of this enterprise challenge the concept of sovereign state? Thank you.
Thank you very much. Really good questions. To what extent does existing law on warfare, international humanitarian law, the law on the conduct of hostilities, as well as protection of victims, apply to cyber issues? The answer is it's not clear. And some elements are clear, but not all elements. As you heard already, the experts group dealing with autonomous weapons already said that basic principles of humanitarian law apply, meaning the principle of distinction. You must distinguish between military and civilian targets, the principle of proportionality and military necessity in terms of ensuring that military advantage is a consideration, but it must not exceed, in terms of proportionality, the harm done to the objects or perhaps collateral damage for civilians. Now, if those are basic principles which are there already, the complications in regard to warfare, particularly in regard to the international law on this, in terms of the shift from an ordinary situation to warfare-related situation, in legal terms, jus ad bellum and jus in bello, is that, number one, the notion of attack is usually one that's a physical notion of an armed attack, but what is a digital attack? There's a bit of a query at this point in time, and we are differentiating between kinetic relationship and non-kinetic relationship. Kinetic meaning a computer or cyber system or cyber-related attack, but it's a physical one of a bomb accompanied by the code, the cyber attacking someone. And that is differentiated from a general cyber digital attack, which might be in a very gray area of when it happens and where, and in terms of accountability. The nearest we have in terms of discussion on this is under soft law discussions of a slightly technical academic kind, but still important in terms of prevention and precaution, and that is known as the Tallinn rules, or the Tallinn manual, Tallinn being in Eastern Europe, and they came together to evolve a certain understanding on this. But as I said, it's still in a state of flux. But we can still try to apply those basic principles such as distinction, proportionality, and necessity, even though the attack factor might not be clear. The other is the objective. Usually when we are dealing with laws of war, we are dealing with military objects or civilians, or civilian objects, something very tangible. But what if it's an attack on something not tangible in terms of digital system? The machine is still there, but it doesn't function anymore. So does one use materiality as a test for the application of the law on this front? When the machine is okay, but the data system is totally wonky? There's a debate. And maybe, from my perspective, maybe we should also think about the harm done. Because the harm done might be that that computer system, if it's dysfunctional or non-functional, might be harming a lot of people. Why? Because it might not be able to protect people. So you're back to square one in terms of law and policy and the taxonomy of relationships. What is the causation and causality in terms of relationship? So I would say that we shouldn't forget the consequences that arise in terms of the attack, even though the computer might be there. But if the system is dysfunctional and has impact on lives around the computer system, maybe it's one that should give rise to accountability. So that's the debate at this point in time. Also, I think there are very simple precepts in terms of the strategy to prevent, the strategy to protect, the strategy to provide remedies, and the strategy to enable people to participate. Those are very simple strategies which enable us to evolve a certain protection system in terms of the laws that we wish to see, whether in terms of cyber or other elements. Lastly, AI law and I think the issue of speech and hate speech and agency and the like. We do have standards. The international law on this is actually drawn from a human rights treaty known as the International Covenant on Civil and Political Rights. And freedom of expression in regard to I like you, I dislike you, is shaped by Article 19 and Article 20. Article 19 ensures your freedom of expression, my freedom of expression, globally, and Thailand is a party to this, subject to two exceptions. One is defamation, when you or I say nasty things to other people, and secondly, when it's in breach of public order or public health or national security. But having said that, all those exceptions are still subject to the three-part test I was referring to earlier in terms of the government still needs to prove legality, necessity, proportionality, and legitimacy. Now that's the general framework for freedom of speech, which is not an absolute right. The other one, which is additional, is in regard to hate. International law doesn't prohibit hate in general unless it falls into this notion of incitement to hatred, which falls under Article 20 of the Covenant on Civil and Political Rights. In other words, it's the relationship of I provoke you to do something nasty to third parties, a triangular relationship, rather than my hating someone as a bilateral relationship. And that is where the law is needed, according to Article 20 of the Covenant on Civil and Political Rights. So that's the framework in terms of the rather old law. But today, because hate speech also evolves and is linked with information, disinformation, and so on, you need other strategies. And that is why I think the SecGen is going to move towards an information integrity code of conduct, soft law next year, to invite strategies, multiple strategies, to tone down the hate in this bilateral relationship. Whereas the trilateral relationship of I provoke you to hate and do something nasty to C is already covered by a prohibition of Article 20. The bilateral relationship depends upon lots of things. I mean, it depends upon education, so that I can be empathetic to you, good socialization, maybe internet industry help. We have internet industry, all these contracts that you click on, they have community standards that are higher sometimes than the international law or national law. Homophobia is forbidden on the internet. I mean, you can't attack gays. You'll be taken down. But that's not the law in many countries. That is a higher standard than the international law, actually, in the traditional sense. So the internet industry can also take charge of setting a high standard in this self-regulation, subject to monitoring by oversight board that they have. And the oversight board of one, Big M, takes down millions per year of hate-related type of speech, including politically related hate speech, which is prominent in some countries, including some democratic countries too. But that's one of the options also. It's not the only option. We have a techno option, the filters also. And we have the other option. I used to help the UN on LGBTI. I got a lot of hate speech, and my successor gets even more. What did I do? They were not hate speech to the extent of defamation. And I didn't want to get involved with national security either. It was my feelings, and how would I respond? How do you think I responded? I used to sit down and pray for people to be kinder to other people. That's how I responded. So please don't think that law or techno is going to solve everything. There is a non-material element of how we deal with not so nice things, which can be, dare I say it, somewhat spiritual and not necessarily religious either. And I still pray for not so nice people to be nice. I make merit. I give money, I don't like to give money to temples very much, but I make merit and pray that autocrats will be kinder to others, because I have to deal with them here and there. So there's different ways. So please don't just look at one strategy, but there is much more than one. And it's both material, non-material, tangential, non-tangential, human, personal, physical, and non-physical, spiritual. So with that in mind, explore our options, and we can start at home. Enable our kids to have good sharing time with us, talkative time, rather than be fixated on digital, which I don't reject, but I don't think we should have digital, the mobile, on the dining table all the time, when we should be chit-chatting nicely, or even if we're not nice, we try to chit-chat nicely to empathize a bit more. So with that in mind, I'd like to thank the Institute very warmly, my friend Dr. Anusorn, and friends and family on the internet and others. And I have one final question for you. In 3 billion years' time, when Andromeda meets the Milky Way, whatever you call it, Andromeda Way, Milkomeda, what will be your thought at that point in time when it meets? What will be the words on your lips as part of humanity when techno meets cosmo in the cosmology of things from here to the other eternity? What will you say to yourself? Can you say it to your neighbor? We should collect this and please send it to the Institute. I'm fascinated. Do you know what I will say? Do you want to hear?
Yes.
You, my friend. Incitement. You want to hear? I will say this. I will say empathy. จิตใจเอื้อเฟื้อเห็นใจเขาเห็นใจเรา Empathy, friendship, and love transcend all. Thank you.
Thank you very much, Professor Vitit, for that last word. Actually, I would say that I won't be there in 3 billion years. Anyway, thank you very much, everybody, for attending this event and make it very lively. I hope you get some provoking ideas to go back and think about it, because I think this is something that will affect probably many people here of younger generation. It won't affect me too much. But I thought this is a good opportunity for you to get some food for thought. So bon appetit, and let's hope we will see you again at our future event. Thank you very much.